Well, I'll be honest, I've looked through some stuff and what I really need to know is why, Ms. Story, your client is opposed to supervised visits if the therapist says that, she will work with the child through the process.
Your Honor, my client's not opposed to supervised visits if the therapist is recommending those. Um, we have an order on file right now that the children, their parenting time with dad and any visitation with dad will be based upon the therapist's recommendation, not mom or dad. And Ms. Lyons and I did that just because of the emotions that are involved in this case, in the criminal case. So if that's what the therapist ends up recommending, then my client is going to follow that, Your Honor.
But their position is that your client's stalling getting the children regularly to the therapist, making appointments, doing them weekly so that progress can't be made for the therapist to make a recommendation.
Your Honor, I believe that is resolved. My client attempted to make payments via her card and they were declined. We reached out to Ms. Lyons and Mr. Metz has since put his credit card on the therapist's, I guess, account. And my client will be taking them weekly. The ones that she did miss or that the children did miss, they were sick, and our exhibits show that they weren't at school that day either. But she intends on informing dad of when they are sick going forward through the parenting app to let him know if those visits are not visits, but therapy appointments cannot be made, and keeping him updated on when they're rescheduled.
And Ms. Lyons, aside from your argument that mom is not being diligent about the therapy so that recommendations can follow, which is what your hope and goal is for your client. Under these circumstances right now, if they are agreeing to the therapist's recommendation, and that is what you proposed, as far as visitation, I'm not sure why we can't move forward and know that mom's going to be accountable to the court with regard to the therapy, and that he will get supervised visitation the minute the therapist is ready for that. In my view, what the therapist needs to do is process any trauma, talk about the relationship with dad, and then if there's a supervised visit, then see how the child reacts and work through that. And I mean, I don't expect this to be something that will take 2 years in therapy before it happens, I guess is what I'm trying to say.
I certainly understand that, Judge. Our position is the court's orders were issued ex parte, right? My client didn't get a vote in them, but that ex parte order says the children, and it was in August, says the children are already in therapy and they need to continue in therapy and no contact with dad until the therapist recommends it, right? And we were on board with that. I think it's important to note that this trauma that we're describing was one 90-second incident on July 17th of 2025, right? And my client has now gone 220 days with no contact with his only children. He can't get a photo. She's not giving him the address. She's apparently moved the children, won't give him the address. She won't tell him any updates about the kids. She's pulled them out of their sports. Their son has played competitive baseball for 5 years. She pulled them out with no notice to dad, all while saying, I'll keep you updated. There's no changes. As recently as 10 minutes before this hearing started, mom has now provided her address and has agreed every 2 months she'll provide a photo of the kids. But Judge, it's not, I understand that the court is now paying attention because this is the very first time we've ever come before the court, because we were trying to do this by agreement, candidly. But our issue is it took until January 28th for mom to even follow her own order, for her to even get the kids into a single therapy session. In 220 days, there has been one less than an hour therapy session solely at mom's hands. She has sole legal custody. She has sole physical custody. My client has no rights to see these children, right? And so our position is, at this point, his absence is causing more harm than whatever that 90-second incident was in July of last year.
Well,
And
all you
so-
need is the therapist to say that.
And we understand that, Judge, and we would love for the therapist to say that, but mom keeps canceling the appointments. They've had 3 and she's canceled 2 of them. And after the first cancellation, I spoke with counsel. I was assured there wouldn't be any more cancellations. And then there was an immediate cancellation. So our request is to start some VEP supervised visits this weekend, see how the kids are doing. They're not acting
No,
out
I'm
in
not gonna do
school.
that. I'm
Okay.
not doing that. Because now it has been so long, and I will take all of that into consideration. And that could very well affect mom in the future in terms of my belief of her veracity and that kind of thing. But the kids were present in this hotel room or wherever this domestic violence
Yes, no question. Yes.
witnessed it. So whether it's a second or 10 minutes,
Mhm.
the trauma's there, and where they're supposed to
Understood.
have fun and they're in the middle of a vacation, they're in a different state. And so I don't want to underplay the seriousness of all of this. I do want to get him reconciled with his children. So I'm thinking that maybe we get a DC coordinator that will make sure that they're corresponding with the therapist and that the therapist appointments are being made. And maybe we have a recommendation from that person as opposed to just solely a therapist.
I don't think my client's opposed to that. I think the parties are maybe going to struggle a little bit financially with that. Mom has now apparently moved to a 3rd location. So now there are 3 housing bills and they couldn't pay the first 2. They're drowning in debt. Their house
They
has now been
listed their
reported.
house. I signed that order for them
We
to.
did, yes, we did get it listed. Or well, I take that back. It's not listed. We did reach an agreement to list it. We've been
Okay.
asking for that since September. I guess all I would ask, Judge, then is can we get a review hearing in 30 days?
Sure.
If the orders are being followed, we can cancel
Sure,
it. But
absolutely.
okay.
We can get a review hearing every 30 days
Okay.
indefinitely.
Okay.
Um,
Because if mom does the weekly therapy she's now saying she'll do, that'll give us 4 more therapy sessions. We'll have a recommendation from the therapist about starting reintegration, and we can keep moving and get this case moving.
yeah.
And we might have an update on the house too.
Usually in situations where there's prolonged lack of contact, where there's asserted violence issue, where there's asserted trauma issues with the kids, there has to be a gradual implementation, as you're well
Yep.
aware. And that's why I think if there's domestic conciliation, that plan can be worked out with,
Okay.
so that when this happens, this happens. If this happens, then this happens. And he can see further down the road.
Yeah.
Instead of just fighting for every inch all the time.
Yeah.
And Judge Satterfield, may I just say for the record,
Sure.
my client was willing, if the orders in the Colorado case said that he could have her address. I spoke with Ms. Lyons this morning and I did not have that order from the Colorado court. I reached out to them, which was one of my exhibits in the email, and had not heard back from them. But Ms. Lyons provided that order to me in her exhibits, and I let her know that we would send that over to her, knowing that that was the order of the court. So that has been sent over to her. I don't want the court to think that my client is trying to withhold that information. We're just trying to follow the order of the criminal case as well as the family law case.
Okay. Well, and if you guys want to, I want you to proffer what you want to proffer for the record, and we can still go ahead and do that.
I think that my client's
Have
main
you guys
concern.
dealt with collaborative resources before? Because that's who I'm thinking about. Or I really liked Paula Langworthy that I used, or somebody used the other day, and she testified. She was very good. But my understanding is that she's running for judge, and so she's limiting her caseload. I don't know who else. Stacy.
I think that
Ortega.
probably Megan and I can come up with some names. I'm thinking more like Christy Campbell.
That's
who's
who I was thinking.
also a GAL because her price point's a little bit more favorable. I think the world of Paula. She's a mentor of mine, but she's pricey. She's real pricey. So I
Well,
think
I mean,
Megan and
they
I can
could
come up
start
with a
with
DC.
mediation works. Could start with mediation.
I think there's
But I
probably,
think we're gonna need recommendations.
I
'cause
think we need a
it's
recommendation.
not
So
the
yeah,
case that I
and
need help with
yeah,
that.
and hopefully we can split Chrissy's fees, and come up with
Okay.
something, Megan.
Yeah, we can do that.
All
We
right.
can figure something out.
Okay.
All right.
I agree
So
with
it's not
Ms.
gonna
Lyons.
totally hinge on the therapist, but there's gonna be coordination with the therapist. And then we'll have the DC recommendations. And hopefully an outline plan that's a progressive one in nature, as long as everything goes according to plan.
Mhm. What is the court's next date so I can get our review on the calendar?
It's a little, it's a week later than 30 days. It's
March
March
19th.
26th,
Oh, okay.
which is a
Okay.
week. Which makes it
Is that
40
at 9?
instead of 30.
That's right.
I have 9 o'clock, 10 o'clock.
I'm
Those
just
are
do
my
9
two
again, Megan.
openings.
Yeah,
or-
I'm free that whole day, so whatever works for your schedule.
Okay. Let's just
Sorry,
do
I'm having a
9.
hard time hearing. My computer won't turn up anymore.
Oh, sorry. We'll just do 9 on the 26th.
Okay. Ms. Lyons, since this
Yes,
is your motion to modify, can you journalize today? And also what you guys agreed to as far as photo and that kind of thing. What is your client's explanation, Megan, for withdrawing their son from baseball?
Your Honor, he had told, well, my client right now has sole legal custody. So I'll start with that, but he has informed, and I mean Jackson, the minor child, that he wants to play basketball this year instead of baseball. And so she did give Dad an update on the app, regarding that. So he's going to be playing basketball, trying basketball this year.
Has he been on a traveling team, or has he been associated or affiliated with whatever organizations exist where he lives, like the Farha group or Derby Rec group or whatever the case may be? Or has he been on a traveling team? He's only 10. It's not like he's 15.
Right.
He's only
It
10.
was a Genesis team. They did travel. And my client was called by the coach and notified. And the coach was like, "Why is your son not playing all of a sudden?" And he's like, "I don't know. I'm sorry. I don't have contact." He reached out to mom, and mom said, it was one sentence. He wants to play basketball. So she didn't volunteer any of this information. That's kind of our issue here. There's been no communication from mom. It's just they're fine.
Well, she's taken her
So,
sole custody status
Yeah.
pretty broadly.
Yeah.
And she did have the right under the temporary orders to make those decisions. So let's see how it fans out. If I need to get CASA involved, I only do those in a handful of cases. I prefer to save it for long distance situations where I'm concerned about the environments, or when kids are borderline sink kids, frankly. But I don't see that here. But if there start being issues about the children's best interest, and presumably both parents act in the best interest of their children. We know they don't always, but presumably they do. So if there becomes some best interest issues, we may have to have a CASA do some background stuff and figure out what's going on.
I think that's part of why Megan and I are kind of leaning towards
Yeah.
Kristen Campbell, because she's that GL. She's got that training.
Right,
Just trying to two
Right.
birds, one stone.
right. And she will talk to kids.
Yeah.
She will.
So what kind of directive can you agree on the directive in terms of the order and what she's free to do?
Oh, yeah.
Oh, I'm sure.
Okay.
Yeah.
Oh,
Just
yeah.
the standard, right, Megan? The
Yeah.
form.
Yeah.
Okay.
Nothing crazy here.
All right, do you want to do some proper here so that you have a record?
What my proffer was as to our request for supervised visits starting this weekend, so I believe the court has already ruled on that. Our concern again is it's been 220 days, so whatever trauma the children may have suffered clear back in July has now been exacerbated by mom's actions in not getting them in therapy unilaterally, not allowing contact, not sending photos, not sending messages, nothing. So is it possible the children were traumatized? Certainly, we're not contesting that. But our position is mom has taken sole legal custody and used it to harm these children by not allowing contact with dad, by not allowing contact with a therapist, not even allowing the school therapist. She didn't even notify the school. The school therapist is free, right? And there
Well,
all the time.
When did he enter into his deferred judgment or diversion? I mean, obviously, he shouldn't violate his bond or conditions of his pretrial release or conditions of anything, and she shouldn't either. So when was the day in which Colorado said you can go back to whatever it is you want to do?
Oh, that was December. Our position, though, is she reported to the court in order to get her ex parte orders that these children were already in therapy to deal with this horrific trauma they
I
supposedly suffered.
understand. And they're saying, yeah, she would have liked to, but the insurance, the costs, the issues.
Yeah, except that she also provided us proof that she didn't even call a single therapist to even try until October 28th.
Okay.
And the price point issue wasn't raised with us till last week, and same day it was remedied.
Okay.
I
And
think
that,
this is pretty clear.
that's well
Deliberate
noted.
actions. Yeah.
That's well noted by the court. All right, let's run through your exhibits real quick. So the motion to modify is A. I
Yes.
looked at that. B is
It's the modified order. They call it a mirroring order that just says Judge Satterfield's orders control as to any contact with the
Okay.
kids. And they did separate orders for each child, so they're B and C. I guess I could have put them together. D is the messages where she says, there's no updates in less than 24 hours later. She said, I'm moving. She has now provided her address.
Okay.
I would note that it required a hearing to get that.
noted.
E is our request for even a single photo of the children and her denying it. Again, as of 10 minutes before the hearing, she is now consenting. F is the school therapist saying, oh, no, I haven't been told anything. I haven't met with the kids. Do you want me to? But he can't, of course, direct her to meet with the kids for free weekly because he doesn't have custody. G is because
So
mom reported.
what's going to be the involvement of the school counselor?
I don't know that there needs to be any.
Okay.
But my question to my client was, well, are the kids meeting with the school therapist? Because mom is now alleging it's too expensive. Maybe they've been meeting with the school therapist if they're so traumatized, or maybe they've been exhibiting behaviors at school if they're so traumatized. And so he reached out and was told, no.
Is Prairie Creek a new school for them?
No,
No,
it's
Your
where
Honor.
they've gone their whole lives.
So he can get into the Andover Power School information and view it. Maybe he can't change
Yes.
anything or do anything, but he
Yes.
can view all of it. Okay,
Correct.
good. All right.
And that I believe is specifically allowed by the order too. I'm pretty sure council specifically put that in there.
And then
so-
G is the therapist that he tried to.
G is the therapist that their son is seeing, Jackson.
Alright.
And we included that because we were told the therapist recommended less therapy for the child. So he reached out to the therapist to find out why they were trying to slow play the therapy. And the therapist said, oh, no, I'm available weekly. Mom asked for less therapy. Same with Exhibit H. Different therapists for a different child reported the exact same thing. I is my client's therapy records because he's been in therapy since August. In compliance with the
Hang on a
orders.
minute. Megan, when did you start seriously conferring with your client in anticipation of this hearing?
Your Honor, we got this motion that Ms. Lyons just filed last week. And I was supposed to be in trial Friday, and then there was not much time to confer with my client on this matter. I will say, Your Honor, that as far as exhibit, sorry, I'm scrolling back through. As far as Exhibit F, the school counselor, my client was informed by Jackson after receiving these exhibit notebooks that he has been pulled out of class and lunch per dad's directive to the school counselor without mom knowing, which would violate the temporary orders there. I want that for the record. We weren't making that a big deal, but if we're going to make a big deal that they haven't even talked to the counselor, dad has directed them to talk to the school counselor. As far as Exhibit G and H, there may have been some miscommunication between Miss Lyons and myself. What was meant to be conveyed to Miss Lyons is that she could not afford the weekly therapy, and that she was requesting an agreement from dad to do bi-weekly, or if we could figure out some sort of payment to do the weekly. That has since been remedied. I think that is being painted to be more malicious than it actually is on my client's
Well, I
behalf.
will say G is most concerning to me because it's very clear the therapist said it was at the behest of mom, and because he's playing baseball and he had a conflicting or a busy schedule with baseball. I mean, that says what it says.
Yes, Your Honor.
That concerns me, and I'm sure you talk to your client about that. And sometimes it takes an attorney getting after their client for them to understand the level of cooperation and goodwill they need to try to offer. So,
And may I proffer, Your Honor, because Miss Lyons has gotten a chance to proffer, and I would like to be able to
yes,
do the
I
same.
will. Yes. Okay. So hey, he's working his side of things, his program.
Yes, he's doing his
And-
individual therapy. He's doing his BIP, which is Exhibit J is in
Okay.
Jaguar.
Okay.
He's in compliance with that. He's only got 6 sessions left of that.
Okay, good.
K is his community service log. I will update it. He has now done 53 hours of community service.
Okay, that one I didn't quite understand. Where is that coming from? The Colorado courts?
Correct.
Okay.
We're just trying
I'm
to
not
show
really
he's doing
monitoring
everything.
that.
Do what?
I'm not really monitoring that.
And I don't think that you need to. There are both sides, both parents are on diversion right now. And so what we're trying to show is that my client is doing everything he can. He's complying with all the orders in both of the states. And it's our position, mom isn't, right? We've got an issue with the house. Now it has now been listed, we've reached an agreed order to list it for sale. Our Exhibit L is one of the financial concerns that we have, which is mom was living in that house. Mom signed an agreed order to pay the mortgage of that house. And then unbeknownst to my client, apparently entered into a hardship forbearance with the mortgage lender, signed my client up for more debt with that mortgage without his knowledge or consent. And we have no idea how that happened, because it's our understanding that in order to modify the terms of a loan, both of the lendees have to sign to it. He didn't
Right.
sign anything. All that happened is he received a notice in the mail that his credit had been hit because the mortgage wasn't paid.
You
When
might be
mom,
able to send them a letter.
Well, and Your
We
Honor,
might-
we have the application. I just got it last night to send to Miss Lyons so that she can look over it. But I would also like to state that that is outside the scope of what her motion was.
Okay, well, we'll take that up later if we have trouble selling the house and it's deteriorated and there are issues with that.
and then Exhibit N is in Nancy is just proof of, it's the payments my client has made in child support. We're not paying through the KPC because the parties still have a joint account, so the money gets to mom faster. Same day if he deposits it into their joint bank account. So that's what we've been doing. And so forgive the Excel spreadsheet, but without a KPC record,
Okay,
this is the best I can do.
well, I think
but-
you need a concession for Ms. Story.
We're not disputing that. The
Okay,
child support
all right.
has been coming through. He has been
Okay.
making those payments, yeah.
Because
And we have the
the
receipt for
preferred
every one of
method
them.
is KPC, especially
And-
parties
yeah.
that seem to be in conflict.
Right, and we
Okay,
entered an
very
agreed
good.
order otherwise, so.
Now I'm gonna
That's
allow Ms. Story, let's
exhibits.
run through yours.
All right, Your Honor. First, I would like to note for the record that we're talking about how this event that occurred is traumatic for the children. And yes, it is traumatic for the children because they witnessed it. But I also want the court to have on the record that this was traumatic for mom as well.
Right.
Mom was strangled in front of her children. That's not disputed. And, things, I don't want to I don't want the court to not have that in their mind when we go through these exhibits. This is a traumatic experience for her. My client doesn't want to be raising children by herself at this point. Yes, dad has been there prior, and then this incident happened and now he's not there. So she has been taking on the sole responsibility as far as physically being there. He has been helping monetarily and we appreciate that, and he has been doing so willingly. And we have made a lot of progress, I believe, in this case as far as getting them on our family wizard to discuss, because that wasn't something we necessarily had to agree to, because that wasn't part of the original temporary orders and that wasn't part of the criminal case as far as a requirement. I think they did allow in the criminal case and I think that's what Ms. Lyons was going to say. They did allow in the criminal case that we could talk through a parenting app. And then Ms. Lyons and I did set that up. But that was not a requirement of this court. I also want the court to know that a lot of these decisions she has made are under sole legal custody. So while I understand that it is incredibly frustrating for father because he has normally been a part of these decisions, he made a decision that harmed both the children and the mother. And some of these responses, honestly, some of my clients' actions or inactions, I believe the court should show some grace because of the traumatic experience that she has been through and the progress that we have been making.
And moving
Previously,
forward, I think,
yes,
yes. And I did want to point out, there is going to be a distinction between the 10-year-old and 5-year-old, as you guys well know.
yes,
Most are going to get out of the 5-year-old is play therapy, which takes
Yes.
longer than a child who can articulate and engage in, processing to some degree, or certainly a greater degree than a 5-year-old. Well, I didn't, what is your client on diversion for? I missed that.
Your Honor, my client is on diversion for a DUI. It was her first time. She's been complying with, I didn't provide updates for that because I didn't believe it was relevant to do so. If mom is complying and we agree that dad has been complying with his,
Okay. When
his
did hers
criminal-
happen in relationship to the Colorado incident?
Hers happened, Your Honor. Let me pull it up.
Hers was in June, his was in July.
Yeah.
Okay.
Yes, Your Honor.
And was hers locally?
Yes, Your Honor.
Okay. Then I'm,
Her DUI case number, if you need it, is 25 TR 1424. It's Butler County case.
okay. So I'm sure there's a no alcohol order as part of that. Or
Yes, Your
certainly
Honor.
she
And her
knows she can't
diversion is our exhibit 13.
drive with the children if she's drinking. If it's not prohibited, I'd have to I haven't looked at those contracts that come out of the county attorney's office like forever.
Your Honor,
We don't approve those, like some courts go through approval of the actual agreement as part of the agreement, but we don't.
Your Honor, her exhibit 13, page 90 or Bates 98 has her conditions for pretrial diversion.
Oh, thank you.
We
Okay.
did include those so that the court would have
thank
that.
you.
I didn't include compliance with everything. I didn't think that would be needed today, Your Honor. But we're not trying to hide
Been testing her compliance for the record.
But we're not trying to hide the DUI.
Okay.
My client made a bad decision and she understands that, just as Mr. Metz made a very bad decision and he is
Okay.
understanding that as well.
And the kids weren't in the car. She would have been charged with endangerment.
No,
So
the kids were not in the car, Your Honor. And this was her first time offense, not
Okay.
saying that she should have done that because she should not have, and she knows that. But this is not something that is a regular occurrence.
okay. Well, under 6, the third bullet point does say as part of the diversion, no alcohol. And of course, everybody knows no illegal drugs. And this is 12 months from
September 8th is when it was filed, Your Honor. I'm looking to September 1st.
okay, so that of 25. So it'll go till September 1st of 26. Okay. So that should take care of that. Because I was trying to figure out, do I do sober link? Do I do an interlock? I don't think I need to at this point. And you're both agreeing that the parties are working their own program. So that's good. All right, what about the rest of your exhibits?
Your Honor, Exhibit 2, we included, which starts on Bates Bates 15, that is, I mean, again, this is just has to do with the DV that occurred. That is her hospital visit after the event occurred towards my client. I include that, Your Honor, again, to just have the court aware my client has also been traumatized and was strangled in front of her children by the father of her children and her husband. So Exhibit 3, that's the no contact order. It does allow talking parents for parenting purposes only. We chose our family wizard instead, just because counsel can have access, and it's has some other options if they get to the point where they can have more contact later on regarding the children. Like it has the phone call features and things like that if it ever comes to that point. Exhibit 4 is the
Was there a firearm issue, or am I confusing this with another case? Okay.
I don't believe there was
I have a case where they thought there was a firearm restriction. They didn't think the party was abiding by it because
Your
the
Honor,
father who took the firearms or something.
that's this case. It's
Okay.
just not accurate. I informed counsel that his father had his guns. He's never lived with his father. There's also an allegation that he was living in a house with a registered sex offender. Also not true. We took care of all of
Okay,
that.
all right, good.
We've cleared those up, Your Honor.
Okay, great.
Yeah.
Anything else you want to point out with your exhibits? Some of these are the court pleadings.
Your Honor, if you scroll to exhibit 15, I want the record to reflect, Your Honor, that my client was not intentionally keeping in any ill will her address from Mr. Metz. She talked with me about it. I did not feel comfortable giving the address without having an order from the Colorado court, which was not provided to Ms. Metz and was not provided to me. I reached out. I still haven't received it, but Ms. Lyons has it and had it in her exhibits, and we talked about it this morning. I also want to note that Exhibit 14 does show that on the day of one of the days that Jackson missed his therapy appointment, he had also missed school because he was sick.
Yeah, and that was going around hard and heavy,
Yes.
all the
And
schools.
my client is not maliciously trying to keep him from the children. There is trauma. We're resolving the Our Family Wizard issue. My client did not feel comfortable at first sending a picture, and I'm going to be honest, I don't blame her for not feeling comfortable sending a picture of the children. The children are working through some trauma. She's working through some trauma. It's difficult for her to talk to Mr. Metz at this time, and she is trying. Her and I have talked. We've come up with a plan. We've presented that to Ms. Lyons, and I am guiding her through that. But I do want the court to have notice that there are trauma responses that are coming from this, both from the children and from my client. And my client needs to be shown a little bit of grace during this period, as she was the victim and she is taking care of these children by herself through no fault of her own. Yes, Mr. Metz is contributing monetarily, but that is not the same as being there.
Right.
And we just don't feel it's safe for him to be there at this point. We want him to eventually be there because Ms. Metz cannot do this on her own. She's going to need him there to be a father to these children. But at this time, we don't feel that it's necessarily safe for them to do so.
Okay. Well, I think what's happened has happened. I mean, it's kind of water under the bridge at this point. Both parties have excellent counsel who can give them very good advice, who know what's expected of them in terms of working together. And when they need to get in front of the court, they were well prepared for today's hearing. They're outstanding attorneys. So I trust that you will advise your client sort of how this all works and the level of cooperation that's needed. And I think reviewing this regularly for a while, it would be good for everyone to see the progress or the lack of, if that's the case. And so we're not at an ideal spot, but I think we're at a better spot than we were before this hearing. So, all right. And Ms. Lyons, I'm asking you to journalize and the two of you to work together, whoever does the order for Ms. Campbell of what it should specifically reflect in terms of her directives.
And Your Honor, I can draft that order. I have
Okay.
one for Christy Campbell specifically already,
Okay.
and so it would just be quick.
Okay,
Works
that'd
for
be
me.
great. All right. Anything
Thanks,
further
everybody.
today?
No, I've got
If
us
you
reset
need
for
me,
March
you'll be able to
26th.
reach me March 2nd, but
Okay,
probably not before then.
have a nice trip.
After tomorrow. Then it'll be March 2nd, okay?
Have a
Otherwise,
nice
you
trip.
can reach my AA, but she's probably not gonna be able to reach me. She's gonna have to go to another judge, whoever's on duty.
No
for
worries.
Emergencies. Okay, take care.
Share your thoughts in the comments, and don't forget to subscribe for more courtroom breakdowns.